Thank you all for coming, and thank you, Liz and Ashley, for inviting me and taking care of all the arrangements. My talk is a deep dive into the legal toolbox, so I am going to be talking about legal stuff. And I've already had a chance to talk to the fellows about some of that legal stuff before coming here. So, quick outline. I'm going to talk a little bit about what the objectives for my presentation are and major themes. And then we're going to go right into that legal toolbox and talk about the way lawyers are looking at the issue of climate change and ocean change. So first of all, I did a little bit of research about IGERT, saw that it prides itself in framing research questions in a problem-driven, socially defined context. And when it comes to this topic, it definitely is problem-driven. It is, one of the most daunting problems that we now are facing. And the trainees, the fellows, explore changing ocean conditions and their impacts on human institutions. And one of the human institutions that I have spent the better part of the last 20 years involved in are legal institutions. And so I feel that one of the things I can bring to the fellows is this concept of what effect changing ocean conditions are having on legal institutions and what legal institutions can bring to bear in terms of facing the problem of ocean change and climate change. So, my objectives: the law and the lawyer as problem solver. I don't know if it's the frog talking to the duck or vice versa, but he says, my lawyer finally got me on the endangered species list. And so what I'm talking about today is how lawyers are being enlisted by those working on addressing the issue of climate change, ocean change, with the tools, including the Endangered Species Act, that are available. Continuing with some of the major themes, and what I hope folks will walk away with is to be conversant in the legal issues related to global climate change, to understand what the tools are in the legal toolbox, and if I use a term that you don't understand, part of the legal toolbox is translating the legalese to English. And so if I use any concept that you don't get, just say, you're talking like a lawyer again, and I will try not to talk like a lawyer. Key objective is to talk about the relationship of science and law. And I had the opportunity to explore that with the students, some very provocative questions about that relationship, and also, is Luann here? Yep. We had a little sidebar before the meeting, and that was a key question in that as well, and one of my key objectives. And then finally, to talk about strengths and weaknesses of what I call lawmaking institutions, and the fora in which they participate. And by lawmaking institutions, I'm talking about the different levels of government: international, national, state, local, and branch of government, federal, federal, state, local, and then the branches within them: the judiciary, the legislative branch, and the executive branch. And so as I get into the details on this, I'm going to be trying to tease out what different institutions that make laws, what their strengths and weaknesses, and what their roles are in addressing the issue of climate change. So, to paint the picture, when we last left our superhero, we had the situation where at the international level we had a treaty, the Kyoto Protocols. U.S. position on that is that we did not ratify them and are not signatories and have not been under its framework. U.S. law, we probably hit a high water mark in 2008 when the House of Representatives passed a comprehensive energy and climate change law, which stalled out without action by the Senate. And so we have an international treaty. We have US law, but we don't have a comprehensive framework. And so what we've been really doing in the absence of an effective international framework or a comprehensive US framework is we've been filling the gap using existing legal tools, and also by a lot of action at the regional, state, and local level. And so what I'm going to be focusing my talk on is really this effort at trying to fill the gap in the absence of the national approach and an international framework. And we can get into questions and answers about those other levels, but I'm going to really be concentrating my remarks now on this gap-filling process that we've been engaged in for really, 10 to 20 years, and the lawyer's role within that. So when I talk about the legal toolbox, what I'm going to be talking about, first of all, common law, and I'll explain a little bit more about what that is. Statutes, people know there are acts, the Clean Air Act, the Endangered Species Act, the Clean Water Act, statutes. Regulations, those are adopted through a process, the rulemaking process, by the executive branch, and we'll be talking about that. Treaties, I've already indicated, at the international level we have. I'm not going to be focusing that much on that. Private agreements are important, but again, I'm not going to be focusing on that. And then litigation. And litigation is a four-syllable word, litigation. Four-syllable word for lawsuit, for being sued. And so, and I will sometimes say, this has been litigated, or this is in litigation. And I'm just saying, people are suing each other over this. So, and I'll be talking a fair amount about the litigation around climate change. So I'll start with the common law. And first thing you'll see, I've talked about it being judgment law. This is law that is not made by adopting through the legislative process a statute. It is not made by the executive branch going out and saying, here are 100 pages of regulations. A judge gets to make this law. And the example we're going to be talking about is nuisance. Now, we're going to do a little audience participation along the way here. And I've already asked the fellows to be helpful with this. So you know who you are. I'm looking at you. You're going to participate. What we're going to do is we're going to divide the audience right around David Fluharty, the distinguished white-haired gentleman there. And for each of these, I'm going to ask one half of the room to be the scientist. And the scientists on the count of three are going to say, will this help climate change? And on the count of three, the other side of the room will either say yes or no. And you can't talk amongst yourselves, you just have to say the first thing that comes to your mind. Okay, so on the count of three, and then we'll switch. So you guys are going to be the scientists. And part of this is communication between the scientists and the lawyers, right? And this is what you want to know. So on the count of three, can the common law help with this problem? 1, 2, 3. Huh? What? Okay, they said, can the common law help with this problem? Well, on the count of three, the lawyers will say yes or no. 1, 2, 3.
No.
Okay, so there was yes and no. Who said no? Okay, why not? Gentleman in the back.
Because I think that it's so indirect to demonstrate nuisance directly coming out of an element of climate change about which the cause can be identified.
Okay. Hard to prove that climate change is causing a nuisance, according to the gentleman back. Who said yes? Nobody will own up to it because they think his answer was so good. Purple shirt.
Why did I say yes?
Yeah.
Well, I'm not sure. I just think it's because a nuisance is something that is affecting other people. Like your neighbor has the music on too loud after 10 p.m. and so it's affecting more than just that person's private property.
Okay. And as a lawyer, I've said many times, I think I can help you. And they say, why? And I say, because I'm a lawyer. I think so. That's good job, Chandler. You're a lawyer. So, but he described what a nuisance is. You're bothering me, right? You're bothering me. And you could look at climate change as sort of the mother of all nuisances, right? I mean, a classic nuisance is pigsty comes in next to your home. And it smells and it's bad. It's disrupting your enjoyment, your quiet enjoyment of your property. You could go to a judge in jolly old England and say, you know, what about this pigsty? And you might get the judge to say, that's a nuisance and it has to stop. So that's what the scientists went to their lawyers and said, can you help? And so some of the lawyers said, well, it's worth a try. And so what I've mapped out here is 3 of the lead cases where the common law of nuisance was tried to deal with climate change. And first one, Connecticut versus American Electric Power. 8 state attorney generals, City of New York, 3 land trusts sued 6 electric power companies, saying the emissions from these power companies are contributing to climate change. It's creating a nuisance, which is, you know, it's not only disrupting my enjoyment, it is potentially catastrophic. Comer versus Murphy Oil, a bunch of folks who were affected by Hurricane Katrina sued a number of energy companies, same theory. The emissions from these energy companies intensified Hurricane Katrina. And that caused a nuisance, right? I've got flooding, I've got, you know, I mean, Katrina was a horror story. Kivalina, native village up on the Arctic Sea, came to the judge, said, Judge, these 24 energy companies and their emissions are causing fundamental changes in the Arctic Ocean, and our village is eroding and falling into the sea. Okay, so does anyone who, well, does this change your mind about? No, he's still saying, you know, I appreciate the pain these guys felt, but I still think that the common law may not be able to help. So, here's how it played out. First it went to the district court judge, and this is all in federal court. District court is the first court that gets to hear it. The judge dismissed the lawsuit and basically said, this is a non-justiciable political question. Non-justiciable means it's not something that can be solved by the judicial system. It's not amenable to this kind of court proceeding. And it's a political question. And I have in quotes there, you know, you're asking me, the judge, to identify and balance economic, environmental, foreign policy, national security interests of a transcendently legislative nature. Take this to the legislative branch. This isn't a court-like problem. And I love transcendentally legislative. I mean, I've been transcendentally many things, but the legislative process is not one of them. So then it goes up to the, and you know, I indicated there were a couple of cases. In general, the district courts did not want to try and get their hands around this. Goes up to the Court of Appeals, and in the United States, if you have gotten into federal court, you can have a right of appeal to the Court of Appeals. They have to hear your case. Court of Appeals looks at the same situation. This was in the American Electric case, and says, these plaintiffs are not asking the court to solve the entire climate change problem. All they're asking is that the court fashion, down here, they seek to limit emissions from 6 domestic coal-fired electricity plants on the ground that such emissions constitute a public nuisance that they allege is causing injury. So here you have the Court of Appeals saying, not so fast. We don't think that we have to solve the entire climate change problem. We just have to look at this and see if these 6 domestic coal-fired electricity plants are causing a nuisance that's causing injury to these plaintiffs. And it's a little more complicated than that because the court went back and forth before it finally got passed on to the Supreme Court. Now, in the United States, you don't have an automatic right to appeal to the Supreme Court. The Supreme Court has to accept your case. The Supreme Court did in this situation, and what they found was that the Clean Air Act preempted the common law of nuisance. And you may be scratching your head at this point and thinking, you know, how did they get to that result? I'll connect that dot in a second. But one of the principles is that we have that law is the court can exercise its power under the common law until the legislature steps in. And if the legislature steps in and basically says, okay, I now understand there's this public problem out there, and you have my attention, here's how we're going to fix this problem. They create legislation, they're the democratically elected body. That law, if it is comprehensive enough, will then preempt the judge from making common law. And so when it went up to the Supreme Court, that's what happened in this case. So we're about to put on our role-playing hats again, and this is a big clue. So take note, the Supreme Court said the Clean Air Act preempted the common law of nuisance. And this time you guys get to be the scientists, and on the count of 3 you get to ask the question, does the Clean Air Act help? And you're going to do a much more forceful job than those guys did when they asked the question. So on the count of 3, does the Clean Air Act help with climate change? 1, 2, 3.
Does the Clean Air Act help with climate change?
Excellent. And you guys are lawyers over here. On the count of 3, yes or no? 1, 2, 3.
Yes.
Okay, somebody said no. I heard a no. Okay, in the back, why?
Because, well, number 1, because it's not being enforced.
Okay. Not being enforced.
Yeah.
Okay. Well, we'll pick that up and run with it a little bit. How about those of you who said yes? Why yes?
Your slide up there.
Yeah, okay. Well, the slide kind of gives it away. You can read ahead, that's fine. But, you know, Clean Air Act. What about clean air don't you understand, right? This could be a statute that is right on target, right? Maybe. All right, so let's walk through it a little bit. Around the same time that the common law case was going on with the state of Connecticut and American Electric, state of Massachusetts, a group of states, a group of environmental groups, sued the Environmental Protection Agency. And they basically were saying, we think that you, EPA, have the authority under the Clean Air Act, under a statute that's already on the books, to deal with climate change. And what happened was the Supreme Court, in a 5-4 decision, as close as you can get, ruled that EPA does have the authority to regulate greenhouse gas under the Clean Air Act. And the key issue in that case, in fact, was whether greenhouse gases were a pollutant as defined by the Clean Air Act. So when I kind of ask facetiously, or say facetiously, what about the Clean Air Act don't you get? There were 4 justices that are on record, in writing, saying, well, air pollutant means many things, but it doesn't mean greenhouse gas. But there were 5 justices who said it does. They remanded this to the Environmental Protection Agency to determine whether greenhouse gas can reasonably be anticipated to endanger public health and welfare. And this endangerment finding is the key under the statute to then have EPA begin to adopt regulations to address climate change. So a couple things to emphasize about this court fight, this litigation. First of all, this played out during the Clinton and Bush administration in general up to the Supreme Court. Clinton administration had gone on record before Congress saying, we think that the Clean Air Act gives us this authority. Bush comes in, and one of the early things that the EPA General Counsel did was said, do over. We don't think that the Clean Air Act gives EPA the authority. And it was along the lines of air pollutant does not include greenhouse gas. Congress at the time it enacted this statute was not thinking about this problem, and therefore really you need to go and get new legislation. Little refinement on how close a call this was. At the Court of Appeals, it was a 2-to-1 split the other way. The Court of Appeals said that the EPA did not have the authority to use the Clean Air Act. And in large part it was because there's a doctrine that in which the courts will defer to the agency that has the expertise in administering it. Not exclusively, but they looked at the argument that the Bush administration had made and basically had, by a 2-to-1 decision, had said, no, Clean Air Act is not available. It's not in the legal toolbox to deal with this. So some things that this particular example illustrates is this interplay between the different branches of government. Remember how I said I was going to try and get into a little bit about the different roles that the branches play and what the interplay is, what they're strong and weak at. So here we have a situation where the legislature had already enacted the law. Clean Air Act, been on the books for decades. And the executive branch, in the first instance, was coming up with its interpretation of whether or not they could use it or not. And that, as you can see, was influenced by a political process. And one president's administration says yes, the other says no, and it goes to the court. The court, that's its primary role in a situation like this. Now, if you compare it to the common law, where the judge was going to have to actually fashion the remedy, under the common law, the judge would have been saying what those power plants had to do. He couldn't send it back to an agency. He had to make the law, or she had to make up the law herself. But in this case, because you have this framework, the court could say, all we're going to do is interpret the statute. And our interpretation is EPA does have the authority. Mr. Fleur.
Could you help us understand how the Court of Appeals trumps a Supreme Court decision?
So, it doesn't. This was, and if I had been linear, I would have done Court of Appeals first, like I did on the other slide, but I really wanted to see how closely people were paying attention. So it doesn't trump it. It's just a kind of additional embellishment. And I'll rearrange the slides the next time I get this.
I had a similar question. How is it established that the different layers of judicial evaluation are endowed with authority to overturn the lower one? Each layer is supposed to be composed of wiser men, or through a more difficult selection process, or I mean, we know what the Supreme Court has to go through. How is it determined that priority exists?
Well, to some extent, it's set forth in the Constitution the role of the Supreme Court as the highest court. And the framework, and I'm not an expert on how the lower courts were established, but they were established with the express purpose of not having everything be decided by the Supreme Court. Supreme Court. And so it's set out very clearly. District court is the court of first review, and there's a mandatory right of the Court of Appeals. All of the judges in the federal system are approved essentially the same way. They don't get as much public scrutiny as the Supreme Court does, but one of the big issues right now is that a lot of federal benches are empty because of the same gridlock that happens with the Senate on other appointments. And so, there's not necessarily wiser people at the different levels. The process has an important element of politics involved in it.
Isn't it the case that it's not a complete redo that happens when an appeals court looks at a decision of a lower court? They're not necessarily reviewing the evidence. They're looking at procedural matters in the case. In other words, aren't you sort of, isn't the question as it percolates up changing form somewhat so that the review is not identical to the one that happened at the lower court?
It depends on the type of case it is. So for example, if the common law cases, the nuisance cases, had gone forward, that judge would have actually held a trial of sorts in which there would have been live testimony, there would have been scientists and others building a record. And when that got appealed to the Court of Appeals would not hold a new trial. It would look at that same record. With regard to the litigation over the Clean Air Act, one of the things that starts off with the DC Court of Appeals, and it doesn't even go through that initial stage, and it's based on the record that's developed by the agency. And so there is not typically, a trial. And then the Supreme Court views any appeal of that on the record as well. So, but it depends on what the nature of the appeal is that's going up. I'm going to kind of forge ahead here. Clean Air Act, here's the rest of the story. So in 2009, after the Supreme Court said, EPA, you have the authority, you have to review the record, the evidence, decide whether greenhouse gas meets this endangerment standard. EPA did that in 2009. They made the endangerment finding, and then they adopted final rules through this regulatory process. And they went out for public comment, and they adopted final rules on vehicle emissions, so emissions from cars, which, according to the record before the court, accounted for 25% of the U.S. greenhouse gas emissions. And they adopted a rule that applied to stationary sources. So, and primarily they put those regulations in place first on the larger ones. So things like the electric facilities that were the basis for the litigation in the common law case are now subject to this stationary source regulation. Now there was litigation, lawsuits over all of this, over the endangerment finding and over these two regulations. The Court of Appeals, summer of last year, upheld all of those pieces. And so there is now, under the Clean Air Act, regulations in place that will have an effect on some of the largest emitters in the U.S. Now, enforcement is going to be a continued issue. Gentleman in the back is right that there are all kinds of statutes and regulations on the books that are only going to be as effective as their enforcement. But in terms of a statute that was on the books that was found to be applicable and is being used now in a concerted way, Clean Air Act is what I would call a success story in terms of this story of litigation to fill the gaps on climate change. Nicole?
Well, so does that mean there are no further common law causes of action?
Aha. So yes, go back. Supreme Court, when the nuisance case finally came up, it took long enough to get to the Supreme Court that they had ruled in Massachusetts versus EPA. And they went back and they said, read what we said in Massachusetts versus EPA. We don't have to decide if this is a political question. All we have to tell you is we've ruled that the statute, the Clean Air Act, preempts the common law of nuisance for purposes of solving this problem. And, you know, without getting into a lot of detail on it, that's kind of debatable. If you look at Supreme Court decisions on preemption, you know, the standard is that the legislature had to have occupied the field, which means basically really comprehensively address the problem. And you could argue that as good as the Clean Air Act is as a tool here, it's not comprehensively dealing with the problem. But, you know, Supreme Court decided that they felt it did. That the Clean Air Act occupies the field, was Congress's way of addressing air problems generally, and was broad enough to address this problem specifically. And so that was how we got to that result in the common law case. Thanks for letting me tie that loop up. So now we're going to talk about the Endangered Species Act, another of the powerful environmental statutes that's out there. And you guys are the scientists again, and you're going to redeem yourself. And on the count of three, you're going to say, can the Endangered Species Act help with climate change? 1, 2, 3.
Yeah. The Endangered Species Act help with climate change.
Okay, somebody said yes. So I'll come back to that. Okay, but you guys get to answer on the count of three. 1, yes or no? 1, 2, 3.
Yes. Yes.
Maybe. Okay. Anyone say no? Anyone in their heart of hearts thinking no? All right, we'll start with the maybe. Oh, no. Gentlemen back.
I had a no, and I thought just because everything has been so ineffectual in making change so far that I don't see any hope for that.
Okay, even after the great story about the Clean Air Act? Okay. So he sort of thinks none of these things are going to work. So I have a constant no on this side that I can count on. That's good. Or not good, depending. Okay, but there was a maybe. So what's the maybe?
I think that it's the same sort of thing where it's not inclusive enough or comprehensive enough that it's going to provide the protection required or get to the issues.
Okay. And there was a yes over here.
I think anytime you have something concrete to work with, it's helpful, whether it ends up accomplishing your goal or showing you what to do next to get to your goal.
Okay. So part of the yes answer is nuanced. You know, it depends on how you define will it help. And we'll talk about that a little bit. There's some other yeses over. Anyone else have a yes? Why they think you were maybe, so I'm gonna...
Well, but no, I'd say yes if you say it had some effect.
Okay.
So I would go with that. But maybe, I stand by my maybe otherwise.
Okay. All right, so let's talk about how this played out. First of all, unless all of you know exactly how the Endangered Species Act works, I'm going to take 3 minutes to talk about some of its salient features. First of all, as you all read ahead, I'm sure, this is a way of identifying and protecting species threatened with extinction. And so you may very well say, what don't you understand about the Endangered Species Act? Of course it's going to help, right? Because, you know, we could all be endangered at this point. We have an endangerment finding under the Clean Air Act that said that climate change was endangering. So the teeth in it are, first of all, if there's a federal action, the agency taking that action has to talk to the scientists. And big questions I've had throughout today was, what role does science play in this? What role did the scientists play? So in this statute, there's actually a formal consultation process, and it's actually called the consultation process, where the agency taking the action consults with the scientists in NOAA and the Fish and Wildlife Service and says, with the question being, will this action jeopardize the continued existence of the species? And that's a species that has already been identified as either threatened or endangered. Second part of that question is, will the federal action modify critical habitat for that species? So you're not only looking at what the effect of the action is on the species, you're looking at what the effect is on its critical habitat. And if the scientists say, yes, this will jeopardize the continued existence of the species, then the next step is the agency that's taking the action has to modify the proposal. Or it is not required by law to modify it, but it's very hard for the agency to ignore the scientists. This is a place where the scientists actually get listened to very seriously. So that's the first effect of the Endangered Species Act. The second is what's called a take prohibition. The species gets listed, and everybody in the United States is prohibited from taking that species. And the easiest way to understand taking is you can't kill it. Now, it's more complicated than that because it would be too easy if it was just... But it's also better for the species because take also is, if you really maim it, you got the species, and it can't eat, and it can't reproduce, and it's going to die. That's also a take. And if you trash its habitat to the point where it's not going to be able to reproduce or feed, that modification of the habitat can also be taken. Now, in order to establish a take, you need to prove it with scientific evidence. So that's another place where the scientists play an important role. They play it on federal actions in this consultation process. If there's a take claim, the scientists would be used in establishing that there was this kind of injury to an individual species. So the way this is played out in practice with regard to climate change is an environmental group, Center for Biological Diversity, petitioned the Department of the Interior to list polar bear. And basically said, we think that polar bear are endangered and they should be listed under the Endangered Species Act. And the Department of the Interior went through a rulemaking process, so this also occurs through regulations. And they identified ultimately that the polar bear not was endangered, but was threatened. And we can talk a little bit about the difference there. But threatened is not as close to extinction as endangered. And the basis for this was not that they're being hunted or that, that there's some other very localized source of threat. In fact, by many standards, the polar bear were fairly healthy. But what the science demonstrated was through climate change, it was predictable and foreseeable that the sea ice was going to continue to melt. And that instead of having ice flows that the polar bear could use to hunt from successfully, that over time you were going to have increasing distances in the ice flows. And the finding was that as a result of climate change, polar bear and the existence of the polar bear, these populations in the Arctic would, their existence was threatened. And so they were designated as threatened. Now, they weren't designated as endangered, and I'll come back to why that matters. At the same time that this was going on with regard to polar bear, similar suits were being brought with regard to certain species of seal in the Arctic and other marine mammals, with less success. And coral is now, in 2012, has been listed. And it's been listed for the Pacific and for the Caribbean. And I'll come back to coral on the next slide. I'll pause. Any questions about Endangered Species Act?
The polar bear was declared endangered threatened in 2009 or before that? Do we know?
You know, it was close to that because you'll recall when Obama ran in 2008, there was a play on his logo that instead of the white center to the logo, there was a polar bear. And so I'm not going to...
I just want to ask another question, is that okay?
Sure.
Does the Endangered Species Act only apply to species that have habitat somewhere within the U.S. Territory, basically, or could it apply anywhere?
It really focuses on these parts of it apply in the United States. There are other parts of the Endangered Species Act that deal with things like importing species that are being, hunted to extinction in Africa and so forth. But this whole listing process really focuses on what's going on within the United States. And part of that has to do with what happens after they're listed and the concept of the take prohibition. And I'll get to that on the next slide. So the first point I have there is what we learned from the polar bear, it's possible to list, but it can be difficult to use in practice. And what I mean by that is what happened after the polar bear were listed, they were listed as a threatened species. And if it's threatened rather than endangered, the Department of Interior in this case, or NOAA in the case of coral, would need to come up with a set of regulations. So again, we're back into this form of lawmaking that's done by regulation. They have to come up with a regulation that says under what circumstances you will prohibit the take of the listed species. And with polar bear, what that means is the opponents were really hoping that what the Department of Interior was going to do is basically say, if a power plant is emitting greenhouse gases in, Iowa, that is contributing to this phenomena that is, threatening the polar bear. And in this consultation process, anytime there's a permit for a power plant anywhere in the United States, you have to start looking at its effect on polar bear. That was the hope in bringing that litigation. But what happened was Interior listed the polar bear as threatened, but then when it adopted the regulation about how it would enforce this concept of you can't take a polar bear, it wasn't going to go after all emissions of greenhouse gas. And so it only got part of what the environmental community was hoping from that act. And I guess, it was Nicole who said maybe, or the gentleman behind who said, no, this is one of the challenges. So when you reach into the legal toolbox and pull out the Endangered Species Act, you may get something, but you may not get the ultimate effect that you're looking for. Now I have here the use of the litigation to affect public opinion, and this gets to the point that there may be other things you get out of litigation other than the win you want. The yes! Kick butt on that one, So you may get something. And in the case, am I allowed to say that? So in this case, this litigation was occurring, how many remember 5 years ago, cover of Time magazine, polar bears, right? Yeah. How many went to the Burke exhibit that showed the polar bears? And, they had pictures of the polar bears with the ice floes, and there were some hurting polar bears. you know, you look at them and say, oh, you know, they're swimming too far, right? How many saw the Burke Museum? Very powerful photographs about polar bear. And so even though it didn't have the effect on the law, at that time it was contributing to a sense of the problem. And it was creating, you know, some of the impetus to develop comprehensive national legislation. I note the role of charismatic megafauna. Just, again, they didn't go after a species that wouldn't look good on the cover of Time magazine. It was like, yeah, if we're going to try and use this act, the Endangered Species Act, if we're going to go into the toolbox for that act, we're going to try and pick a species that will really grab people's attention. So rest of the story, I noted coral was listed 2012 extensively. Pacific and the Caribbean. There will be litigation over that listing, and it's unclear yet what regulations, and in this case it's NOAA who will adopt the regulations, what they'll put into place. So, yes?
Listed as threatened or endangered?
I think it's a combination of both. I think some of the species are listed as threatened and endangered, and I think that, that it's not entirely based on climate change the way polar bear was. Polar bear, it was really, this is what is causing it. And so I think that the way that coral is addressed in the regulations is going to be, I think there will be a lot of different layers to it based on what's going on with each of those species. The thing that you can well imagine, the public process on this already has generated a lot of attention. People concerned about fishing grounds, people concerned about recreation and other uses. And so this will be, I think, the real proving ground on how useful this Endangered Species Act is addressing this issue, and in particular with regard to ocean acidification, because that's the way that this is you know, when you look at the cause with regard to coral, it really gets into the ocean acidification phenomenon. National Environmental Policy Act, NEPA. Okay, so I think you guys get to be the scientists this time. 1, 2, 3. We have the
National Environmental Policy Act.
Yeah.
Climate change.
And the lawyers say, this guy says no. No. Maybe? No. Okay. So just in the interest of time, I'm going to blitz through this. You guys get the idea about the way the scientists and the lawyers talk to each other. A lot of yes, no, maybe. And with gusto, you know. The scientists really have to be passionate when they ask the question. So, NEPA, that's where we get environmental impact statements from. The directive is to review environmental impacts of federal actions. One thing I didn't explain before when I was talking about the Endangered Species Act, what do I mean by a federal action? So garden variety federal action is the Corps of Engineers issues a permit to fill wetlands under the Clean Water Act. Or the Corps of Engineers issues a permit to build a dock under the Rivers and Harbors Act. And you don't have, we're not going to be quizzed on those. Issuing a permit is a classic federal action. The licenses for our hydroelectric projects, you know, NEPA, ESA get triggered. Federal funds, discretionary federal funds. Federal Highway Administration gives a bunch of money to build highway extension. NEPA, it's a federal action. Now this isn't like the Endangered Species Act. It's procedural, not substantive. What I mean by that is, Endangered Species Act, there was that question about, is it going to endanger, or is it going to jeopardize the continued existence of the species or modify habitat? If the answer is yes under ESA, it's action forcing. NEPA doesn't have that. You have to study it, but you don't have to do anything based on what the outcome of that analysis is. The hope is you will. The hope is that by bringing the environmental issues into the decision making, it will affect decision making. Case law, this has been litigated. EISs have been challenged about whether or not they looked at climate change sufficiently. The courts say you have to look at it. The big fight is over what it means to look at it sufficiently. Council on Environmental Quality has drafted guidelines, but there are no regulations. There's no regulations that say, how do you look at climate change under NEPA? And some things to keep your eyes tuned to and your ears tuned to. In the news in the last couple of days, the State Department has issued its draft environmental impact statement on the Keystone XL pipeline. And its conclusion was that the pipeline, that action, approval of the pipeline coming in the United States, will not have a measurable effect on climate change. This will play out in local litigation. We talked about it extensively with the fellows before coming here on the coal terminal projects. The coal terminal projects that are receiving a lot of attention are going to be heavily litigated over the way climate change is reviewed in those environmental impact statements. And just in the interest of finishing on time, I'll save that for questions at the reception, or if we have a couple minutes at the end. NEPA, the bottom line is, let me see if I have another slide on it. Nope. Bottom line on NEPA is there will be a lot of time and effort spent on discussing climate change and environmental impact statements. NEPA, because it is procedural and doesn't force the action agency to do anything different, will have limited teeth in dealing, effectively with this. So it is a tool in the toolbox. It is being used right now in the state of Washington to generate a lot of public debate over the coal terminals itself, but it doesn't have teeth in it. So the last statute I wanted to talk about is Clean Water Act. And I'll just be the scientist. So what do you guys think? Clean Water Act, is that going to help us? How many people say yes?
Yes.
How many people say no? Okay, so what the Clean Water Act does is it prohibits people from discharging pollutants into the United States. Now, the real challenge with the Clean Water Act is that, and climate change is the phenomena of ocean acidification, and this is where people have tried to use it. It's not from the result of somebody dumping something into the ocean. It's the result of something being emitted into the air. And then the ocean takes it up. And so there was litigation trying to get the state of Washington to use the Clean Water Act to deal with ocean acidification. And it was effective, I think, in general about ocean acidification. The ultimate result of that litigation was really the finding that that the Clean Water Act itself was not going to be the best tool. I've got some links here, and the PowerPoint will be available. If people are really interested in what happened with regard to state of Washington and this effort to try and deal with ocean acidification using this tool, get the PowerPoint, go to the webs, and this is very current in terms of what's happening in the state trying to use the Clean Water Act tools. But again, it's sort of a tool that was there in the effort to fill the gap of not being part of the international regime or having a national framework. This was another place that the environmental community went to see if they could raise attention, get some regulatory assistance, and it was not ultimately successful the way I think that they had hoped, but it had some of the benefits of generating discussion and awareness of the issue. So, to conclude, we're back to our charismatic megafauna. And, Kermit's motto was, "It's hard being green." And I think he's right in today's climate. But he got Lady Gaga to kiss him, and that's worth something. But the real point of this slide, and where we are, and how legal institutions are being brought to bear, and how climate change is affecting legal institutions, is there's the old saying that you have to kiss a lot of frogs to find a prince. And the history of litigation on this issue for the last decade or more has really been scientists saying to lawyers, will this statute help? The lawyers going to their various tribunals, either to the executive branch to ask for rules or listings under the Endangered Species Act, and ultimately the courts are being the arbiters of whether this frog is going to be the prince that's helpful in dealing with climate change. Ultimately, I think that there is another better looking frog out there to address these issues than the ones that are currently available in the legal toolbox. But, for now we are going to be kissing frogs. So with that, I'm done. Thank you.
I think we have time for one question. I saw the first hand go up in the middle.
It doesn't follow directly on what you said, but what about product liability failure to warn and an approach to tackle energy crisis? It's been proposed in the literature, and we just ran a mock trial on this. I'm curious to know.
Oh, okay. Well, I don't know. So what did the mock trial?
Well, it was made up, and I'm not a lawyer, so it was the state of Louisiana petitioning what we call swell oil and swell oil. Because of the issues around defining, contributions and responsibility and time frame and causality and all those different things, and then also the issues about whether or not behaviors would have changed if there had been a warning. But I'm curious. I guess you haven't looked into it.
I haven't looked into that, but what I would say, so the basic idea there is that we all know that you can sue a company over the safety of its product. That's what product liability litigation is. So this would be a lawsuit against, an oil company over the safety of burning oil. So you would go to the pump, and they're just like when you get your pack of cigarettes and it says, the Surgeon General says this may be hazardous to your health. You would have a warning that says, pumping this tank of gas would be hazardous to your health in the way that we have talked about. So, how many of you hearing that think, yeah, this is likely to work?
Yeah.
Yeah. Okay.
Yeah. Like it.
Do we have time for any?
Let's do one more, and then we'll direct the final questions during the reception right outside the fort.
Is that one?
Go ahead, Tom.
She gets to choose.
Tom, go for it.
Okay, thank you. One thing you didn't touch on, there's a whole other arena of international law, and there are a number of nation states or disadvantaged people around the world. I guess comes to mind maybe Tuvalu in the Central Pacific, threatened with getting overwhelmed by rising sea levels, and also the Nunavut of northern Canada, where people are basically going to international courts, the International Court of Justice, and saying essentially that the nations of the world who are causing global warming are guilty of human rights abuse. So this is a very different kind of argument, but it's one that can actually be made in those settings. Can you comment on that kind of thing and what it's likely to yield in the long run?
I have not been following those. I am aware that they are occurring. And anyone else following this? I don't know.
Well, let's save any last questions for the reception. Next week, the Dean of the College of Environmental